Disability Rights Arizona presents Housing Accommodations and Modifications for People with Traumatic Brain Injuries. This video will review the fair housing rights of individuals with traumatic brain injury, or TBI, who may need reasonable accommodations or modifications in order to have equal access to their housing. The Fair Housing Act is a federal law that protects people with disabilities from discrimination on the basis of their disability in housing. There is also an Arizona Fair Housing Act that contains the same protections. The Fair Housing Act covers most housing and housing providers with some specific exceptions. The requirements of the Fair Housing Act apply to landlords, homeowners associations, property managers, realtors, and others. The Fair Housing Act prohibits a housing provider from direct discrimination. For example, failure to rent an apartment or sell a home to someone because they have a disability. It also prohibits housing providers from refusing to allow reasonable modifications and reasonable accommodations that are necessary to afford a person with a disability equal opportunity to use and enjoy the housing. A reasonable modification is a structural change to allow the person with a disability full enjoyment of the premises. Some examples of reasonable modifications in housing include installation of ramps, widening doorways, installation of grab bars in the bathroom, replacing hardware like doorknobs, and lowering counter heights. There are exceptions, but generally speaking, reasonable modifications are made at the expense of the person who needs the modification. A reasonable accommodation is a change, exception, or adjustment to a rule, policy, practice, or service that may be necessary for a person with disabilities to have an equal opportunity to use and enjoy their housing, including public and common use spaces, or to fulfill their program obligations. Some examples of reasonable accommodations in housing include exceptions to no pets policies for assistance animals, an additional bedroom beyond what the person qualifies for in order to allow for a live-in aide who stays overnight to assist, copying a requested third party on payment notices to help with reminders, an assigned parking space, the ability to change units or terminate a lease early, and being provided a lease application in large print. Reasonable accommodations are made at the expense of the housing provider. Housing providers do not have to make a reasonable accommodation that causes an undue financial burden or that causes a basic change in the nature of the housing program. If a person with a TBI needs a reasonable modification or reasonable accommodation in order to have equal access to their housing, they will need to make a request to their housing provider. Requests are based on the individual needs of the person with a TBI. Here are some tips for making a reasonable accommodation or modification request. Tip number 1. Put your request in writing. Requests can be made orally or in writing, but putting the request in writing is recommended so that there is a record of what you asked for and when you asked. No special forms or magic words are required to make the request, though your housing provider may have forms they want you to use. Someone else can also make a request on behalf of a person with a disability if assistance is needed. Tip number 2. Write a strong request. Elements of a strong request include stating where you live and who is responsible for the building, stating you qualify as a person with a disability as defined by the Fair Housing Act, describing the architectural barrier, policy, or rule that is problematic for you and how it relates to your disability, describing how this barrier, policy, or rule interferes with your needs in use or enjoyment of the housing. In clear, direct language, describe the accommodation or modification you are seeking, and request a response by a specific deadline. You can make a reasonable accommodation or modification request at any time, including in the application process, during your tenancy, and in moving out, even if you're in eviction proceedings. Tip number 3. Provide supporting documentation where required. In cases where the person's disability is not observable and known, or if the disability-related need is not obvious, supporting documentation is required. Supporting documentation can be a letter from a doctor or other provider who can tell the housing provider why you need the reasonable accommodation or modification. The letter writer should explain the relationship to the person, state that the person has a qualifying disability, describe the functional limitations the person experiences because of their disability, explain the disability-related need for what is requested and the connection between the disability and the request. State that what is requested is needed in order to have equal use and enjoyment of the housing. Tip number 4. Keep copies for your records. You should save copies of everything you submit to your housing provider. You will want copies in the event a dispute arises during the approval process, or later down the road if there is a change in management. Tip number 5. If the housing provider denies the request, you can take steps to enforce your fair housing rights. You can file a charge of housing discrimination with the Arizona Attorney General's Office Civil Rights Division, or the U.S. Department of Housing and Urban Development. Remember, charges must be filed within 1 year of the discrimination. You may also file a lawsuit under the Fair Housing Act without filing an administrative charge. In Arizona, if you wish to file a lawsuit under the Fair Housing Act, you must do so no later than 2 years after the alleged discriminatory action. To access more information about fair housing rights, visit Disability Rights Arizona's website at disabilityrightsaz.org or call 602-274-6287. The information presented is intended to be used for informational purposes only and is not legal advice. If you have specific questions or want legal advice, please contact a qualified attorney in your state.